An impeachment trial, an impeachment inquiry is not a criminal trial and should not be confused with it. Believe me, what has taken place in these proceedings is not to be confused with due process. Because due process demands, and the Constitution requires, that fundamental fairness and due process, we're hearing a lot about due process is designed to protect the person accused. When the Russia investigation failed, it devolved into the Ukraine. A quid pro quo. When that didn't prove out, it was then bribery or maybe extortion, or somebody said, one of the members or the members of the House said treason. But instead we get two articles of impeachment. Two articles of impeachment that have a vague allegation about a non-crime allegation of abuse of power and obstruction of Congress. Managers, right here, before you today, who have said that executive privilege and constitutional privileges have no place in these proceedings. On June 28, 2012, Attorney General Eric Holder became the first United States Attorney General to be held in both civil and criminal contempt. Why? Because President Obama asserted executive privilege. With respect to the Holder contempt proceedings, Mr. Manager Schiff wrote, "The White House assertion of privilege is backed by decades of precedent that has recognized the need for the President and his senior advisors to receive candid advice and information from their top aides." Indeed, that's correct. Not because Manager Schiff said it, but because the Constitution requires it. Mr. Manager Nadler said that the effort to hold Eric Holder, Attorney General Holder, in contempt for refusing to comply with various subpoenas was, quote, politically motivated, and Speaker Pelosi called the Holder matter, and I quote, a little more than a witch hunt. What are we dealing with here? Why are we here? Are we here because of a phone call? Or are we here before this great body because since the president was sworn into office, there was a desire to see him removed? I remember in the Mueller report, there were discussions about, remember, insurance policies. The insurance policy didn't work out so well. So then we moved to other investigations. I guess you would call it reinsurance or an umbrella policy. And that didn't work out so well. And here we are today. Manager Schiff quoted the Supreme Court, and I'd like to make reference to the Supreme Court as well. It was then Justice Rehnquist, later to be Chief Justice Rehnquist, who wrote for the majority in United States versus Russell in 1973. These are the words. "We may someday be presented with a situation in which the conduct of law enforcement agents is so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. That day is today." That day was a year ago. That day was in July, when Special Counsel Mueller testified. I am not today going to take the time to review, and I will do it later, the pattern and practices of irregularities that have gone on in these investigations from the outset. But to say that the courts have no role, the rush to impeachment, to not wait for a decision from a court on an issue as important as executive privilege, as if executive privilege hasn't been utilized by presidents since our founding. This is not some new concept. We don't waive executive privilege, and there's a reason we keep executive privilege, and we assert it when necessary, and that is to protect to protect the Constitution and the separation of powers. The president's opponents, in their rush to impeach, have refused to wait for complete judicial review. That was their choice. Speaker Pelosi clearly expressed her impatience and contempt for judicial proceedings when she said, "We cannot be at the mercy of the courts." Think about that for a moment. We cannot be at the mercy of the courts. So take Article 3 of the United States Constitution, remove it. We're acting as if the courts are an improper venue to determine constitutional issues of this magnitude. That is why we have courts. That is why we have a federal judiciary. It was interesting when Professor Turley testified before the House Judiciary Committee in front of Mr. Nadler's committee. He said, "We have three branches of government, not two. If you impeach a president, if you make a high crime and misdemeanor out of going to courts and abuse of power, it's your abuse of power." You know, it's more than that. A lot more than that. There's a lot more than an abuse of power if you say the courts don't apply. Constitutional principles don't apply. Let's start with a clean slate as if nothing happened. A lot has happened. As we proceed in the days ahead, we will lay out our case. We're going to put forward to the American people, but more important, for the Constitution's sake, what's taken place here. But this idea that we should ignore what has taken place over the last 3 years is outrageous. We believe that what Senator McConnell has put forward provides due process, allows the proceedings to move forward in an orderly fashion. 33 days. 33 days they held on to those impeachment articles. 33 days. It was such a rush of national security to impeach this president before Christmas that they then held him for 33 days. To do what? To act as if they negotiate, the House of Representatives should negotiate the rules of the United States Senate. They didn't hide this. This was the express purpose. This was the reason they did it. We're prepared to proceed. Majority Leader, Democratic Majority Leader, we're prepared to proceed. In our view, these proceedings should begin. I yield the rest of my time to my colleague, the White House counsel. Thank you, Mr. Chief Justice.
Cipollone.
Thank you, Mr. Chief Justice. I just want to make a couple of additional points. It's very difficult to sit there and listen to Mr. Schiff tell the tale that he just told. Let's remember how we all got here. They made false allegations about a telephone call. The President of the United States declassified that telephone call and released it to the public. How's that for transparency? When Mr. Schiff found out that there was nothing to his allegations, he focused on the second telephone call. He made false, and his colleagues made false allegations about that second telephone call that occurred before the one he had demanded. So the President of the United States declassified and released that telephone call. Still nothing. Again, complete transparency in a way that, frankly, I'm unfamiliar with any precedent of any President of the United States releasing a classified telephone call with a foreign leader. When Mr. Schiff saw that his allegations were false, and he knew it anyway, what did he do? He went to the House and he manufactured a fraudulent version of that call. He manufactured a false version of that call. He read it to the American people, and he didn't tell them it was a complete fake. Do you want to know about due process? I'll tell you about due process. Never before in the history of our country has a president been confronted with this kind of impeachment proceeding in the House. It wasn't conducted by the Judiciary Committee. Now, Mr. Nadler, when he applied for that job, told his colleagues when they took over the House that he was really good at impeachment. But what happened was the proceedings took place in a basement of the House of Representatives. The president was forbidden from attending. The president was not allowed to have a lawyer present. In every other impeachment proceeding, the president has been given a minimal due process. Nothing here. Not even Mr. Schiff's Republican colleagues were allowed into the SCIF. Information was selectively leaked out. Witnesses were threatened. Good public servants were told that they would be held in contempt. They were told that they were obstructing. What does Mr. Schiff mean by obstructing? He means that unless you do exactly what he says, regardless of your constitutional rights, then you're obstructing. The president was not allowed to call witnesses. By the way, there's still evidence in the SCIF that we haven't been allowed to see. I wonder why. No witnesses. Now let's think about something else for a second. Let's think about something else. They held these articles for 33 days. We hear all this talk about an overwhelming case that they're not even prepared today to stand up and make an opening argument about. That's because they have no case. Frankly, they have no charge. When you look at these articles of impeachment, they're not only ridiculous, they are dangerous to our republic. And why? First of all, the notion that invoking your constitutional rights to protect the executive branch, that's been done by just about every president since George Washington, that is obstruction. That is our patriotic duty, Mr. Schiff, particularly when confronted with a wholesale trampling of constitutional rights that I'm unfamiliar with in this country. Frankly, it's the kind of thing that our State Department would criticize if we see it in foreign countries. We've never seen anything like it. And Mr. Schiff said, have I got a deal for you? Abandon all your constitutional rights. Forget about your lawyers and come in and do exactly what I say. No, thank you. No, thank you. And then he says he has the temerity to come into the Senate and say, we have no use for courts. It's outrageous. Now, let me tell you another story. There's a man named Charlie Kupperman. He is the Deputy National Security Advisor. He is the number 2 to John Bolton. Because you have to remember, Mr. Schiff wants you to forget, but you have to remember how we got here. They threatened him. They sent him a subpoena. Mr. Kupperman did what any American should be allowed to do, used to be allowed to do. He was forced to get a lawyer. He was forced to pay for that lawyer. And he went to court. Mr. Schiff doesn't like courts. He went to court. And he said, Judge, tell me what to do. I have obligations that frankly rise to what the Supreme Court has called the apex of executive privilege in the area of national security. And then I have a subpoena from Mr. Schiff. What do I do? You know what Mr. Schiff did? Mr. Kupperman went to the judge, and the House said, never mind, we withdraw the subpoena. We promise not to issue it again. And then they come here and they ask you to do the work that they refuse to do for themselves. They ask you to trample on executive privilege. Now, would they ever suggest that the executive could determine on its own what the speech or debate clause means? Of course not. Would they ever suggest that the House could invade the discussions that the Supreme Court has behind closed doors? I hope not. But they come here and they ask you to do what they refuse to do for themselves. They had a court date. And they withdrew the subpoena, they evaded a decision, and they're asking you to become complicit in that evasion of the courts. It's ridiculous. And we should call it out for what it is. Obstruction for going to court? It's an act of patriotism to defend the constitutional rights of the president, because if they can do it to the president, they could do it to any of you, and they could do it to any American citizen, and that's wrong. And Lawrence Tribe, who's been advising them, I guess he didn't tell you that in the Clinton impeachment he said, it's dangerous to suggest that invoking constitutional rights is impeachable. It's dangerous. And you know what? It is dangerous, Mr. Schiff. So what are we doing here? Okay. We have the House that completely concocted a process that we've never seen before. They locked the president out. Oh, and by the way, will Mr. Schiff give documents? We asked him for documents. We asked him for documents when, contrary to his prior statements, it turned out that his staff was working with the whistleblower. We said, let us see the documents, release them to the public. We're still waiting. So the idea that they would come here and lecture the Senate. By the way, I was surprised to hear that, did you realize you're on trial? Mr. Nadler's putting you on trial. Everybody's on trial except for them. It's ridiculous. It's ridiculous. They said in their brief, we have overwhelming evidence, and they're afraid to make their case. Think about it. Think about it. It's common sense. Overwhelming evidence to impeach the President of the United States. And then they come here on the first day and they say, you know what, we need some more evidence. Now let me tell you something. If I showed up in any court in this country and I said, Judge, my case is overwhelming, but I'm not ready to go yet. I need more evidence before I can make my case. I would get thrown out in 2 seconds. And that's exactly what should happen here. That's exactly what should happen here. It's too much to listen to almost. The hypocrisy of the whole thing. And what are the stakes? What are the stakes? There's an election in almost 9 months. Months from now, there's going to be an election. Senators in this body the last time had very wise words. They echoed the words of our founders. A partisan impeachment is like stealing an election. And that's exactly what we have. We have, talk about the framers' worst nightmare. It's a partisan impeachment that they've delivered to your doorstep in an election year. Some of you are upset because you should be in Iowa right now. But instead we're here, and they're not ready to go. And it's outrageous. It's outrageous. And the American people won't stand for it, I'll tell you that right now. They're not here to steal one election, they're here to steal 2 elections. It's buried in the small print of their ridiculous articles of impeachment. They want to remove the President Trump from the ballot. They won't tell you that. They don't have the guts to say it directly, but that's exactly what they're here to do. They're asking the Senate to attack one of the most sacred rights we have as Americans, the right to choose our president in an election year. It's never been done before. It shouldn't be done before. Now, the reason it's never been done is because no one ever thought that it would be a good idea for our country, for our children, for our grandchildren, to try to remove a president from a ballot, to deny the American people the right to vote based on a fraudulent investigation conducted in secret with no rights. Well, I could go on, but my point is very simple. It's long past time that we start this so we can end this ridiculous charade and go have an election. Thank you very much, Mr. Chief Justice.
Does the President's counsel yield back the remainder of their time? We do. Thank you. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain documents and records from the White House, and I ask that it be read.
The clerk will read the document.
The senator from New York, Mr. Schumer, proposes an amendment number 1284. At the appropriate place in the resolving clause, insert the following. Section, notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules and Procedure and Practice in the Senate when sitting on impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the acting Chief of Staff of the White House, commanding him to produce, for the time period from January 1st, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the White House, including the National Security Council, referring or relating to A, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21st and July 25th, 2019 telephone calls, as well as the President's September 25th, 2019 meeting with the President of Ukraine in New York. B, all investigations, inquiries, or other probes relating to Ukraine, including any that relate in any way to 1, former Vice President Joseph Biden, 2, Hunter Biden and any of his associates, 3, Burisma Holdings Limited, also known as Burisma, 4, interference or involvement by Ukraine in the 2016 United States election, 5, the Democratic National Committee, or 6, CrowdStrike. C, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF. D, all documents, communications, notes, and other records created or received by Acting Chief of Staff Mick Mulvaney, then National Security Advisor John R. Bolton, Senior Advisor to the Chief of Staff Robert B. Blair, and other White House officials relating to efforts to 1, solicit, request, demand, induce, persuade, or coerce Ukraine to conduct or announce investigations, 2, offer, schedule, cancel, or withhold a White House meeting for Ukraine's president, or 3, hold and then release military and other security assistance to Ukraine. E, meetings at or involving the White House that related to Ukraine, including but not limited to 1. President Zelensky's inauguration on May 20th, 2019 in Kiev, Ukraine, including but not limited to President Trump's decision not to attend to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and subsequent decision about the composition of the delegation of the United States. 2. A meeting at the White House on or around May 23, 2019, involving, among others, President Trump, then Special Representative for Ukraine negotiations, Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union, Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3. Meetings at the White House on or about July 10, 2019, involving Ukrainian officials Andrei Yermak and Oleksandr Danilyuk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and subsequent meeting in the wardroom. 4. A meeting at the White House on or around August 30th, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper. 5. A planned meeting later canceled in Warsaw, Poland, on or around September 1st, 2019, between President Trump and President Zelensky, and subsequently attended by Vice President Pence. And 6, a meeting at the White House on or around September 11, 2019, involving President Trump, Vice President Pence, and Mr. Mulvaney concerning the lifting of the hold on security assistance for Ukraine. F, meetings, telephone calls, or conversations related to any occasions in which the National Security Council officials reported concerns to National Security Council lawyers, including but not limited to National Security Council legal advisor John Eisenberg regarding matters related to Ukraine, including but not limited to 1. The decision to delay military assistance to Ukraine. 2. The July 10, 2019 meetings at the White House with Ukrainian officials. 3. The President's July 25, 2019 call with the President of Ukraine. 4. A September 1, 2019 meeting between Ambassador Sondland and a Ukrainian official. And 5. The President's September 7, 2019 call with Ambassador Sondland. G. Any internal review or assessment within the White House regarding Ukraine matters following the September 9, 2019 request for documents from the House Permanent Select Committee on Intelligence, the House Committee on Oversight and Reform, and the House Committee on Foreign Affairs, including but not limited to documents collected that pertain to the hold on military and other security assistance to Ukraine, the scheduling of a White House meeting for the President of Ukraine, and any requests for investigations by Ukraine. H, the complaint submitted by a whistleblower within the intelligence community on or around August 12, 2019 to the Inspector General of the intelligence community. I, all meetings or calls, including requests for or recordings of meetings or telephone calls, scheduling items, calendar entries, White House visitor records, and email or text messages using personal or work-related devices between or among 1. Current or former White House officials or employees, including but not limited to President Trump, and 2. Rudolph W. Giuliani, Ambassador Sondland, Victoria Tunsang, or Joseph DeGenova, and J. Former United States Ambassador to Ukraine, Marie Masha Yovanovitch, including but not limited to the decision to end her tour or recall her from the United States Embassy in Kiev, and 2. The Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the United States Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice,
The Majority Leader is recognized.
I now ask for a brief 15-minute recess before the parties are recognized to debate the Schumer amendment. Therefore, I ask consent the Senate stand in recess, subject to the call of the chair.
Without objection, so ordered.
Well, somebody please, there you go. I'd like to remind everybody to take your seats, and when the Chief Justice comes in, we really should all stand.
Senate will come to order. There are now 2 hours of argument on Senator Schumer's amendment. Mr. Schiff, do you wish to be heard on the amendment in proponent or as an opponent? Chief Justice, we wish to be heard as we are proponent of the amendment. Very well. Mr. Cipollone?
Mr. Chief Justice, we are an opponent.
Okay. Mr. Schiff, you have an hour.
Thank you, Mr. Chief Justice. In a moment, I will introduce House Manager Lofgren of California to respond on the amendment. But I did want to take this opportunity before certain representations became congealed to respond to my colleague's argument on the resolution at large. First, it's worth noting they said nothing about the resolution. They said nothing about the resolution. They made no effort to defend it. They made no effort to even claim that this was like the Senate trial in the Clinton proceeding. They made no argument that, well, this is different here because of this or that, or they made no argument about that whatsoever. They made no argument that it makes sense to try the case and then consider documents. They made no argument about why it makes sense to have a trial without witnesses. And why? Because it's indefensible. It's indefensible. No trial in America has ever been conducted like that. And so you heard nothing about it. And that should be the most telling thing about counsel's argument. They had no defense of the McConnell resolution because there is none. They couldn't defend it on the basis of Senate precedent. They couldn't defend it on the basis of Senate history, tradition. They couldn't defend it on the basis of the Constitution. They couldn't defend it at all. And so what did they say? Well, first they made the representation that the House is claiming there is no such thing as executive privilege. That's nonsense. No one here has ever suggested there's no such thing as executive privilege. But the interesting thing here is they've never claimed executive privilege. Not once during the House investigation did they ever say that a single document was privileged or a single witness had something privileged to say. And why didn't they invoke privilege? Why only now? And even now they haven't quite invoked it. Why only now? Why not in the House? Because in order to claim privilege, as they know because they're good lawyers, you have to specify which document.